Good evening, all. I'm Tejasvi from Public Relations Office. It's a pleasure to introduce today's guest speaker, Advocate Niranjan Mundargi. Mr. Mundargi is a reputed criminal counsel who has been practicing predominantly before the Bombay High Court and other special criminal courts for the last 24 years. After completing his bachelor's degree in commerce from Pune, Mr. Mundargi earned a law degree from New Law College and an LLM from the University of Mumbai. He began his career as a junior to advocate Ashok Gupte and then worked as a junior in the chambers of senior advocate Ashok Mundargi. In 2008, he started his own chambers with about 21 juniors working under him. Mr. Mundargi has handled several cases, including the high profile ones. He also deals with the matters pertaining to the special legislation like the Prevention of Money Laundering Act 2002, the Factories Act 1948, the Arms Act of 1959, and many more. I would now like to invite Mr. Niranjan Mundargi to begin with his talk.
Firstly, I think it's a privilege I feel that I am called here to address the best brains in this country. So I am thankful to the IIT Powai for inviting me here, and also one more thing I would like to share with all of you, that exactly 31 years back in month of May 1993 I was staying in this institute for a month. I was selected for a national camp for badminton, and I was staying in one of the hostel rooms, and our camp was held within this premises. So it takes me to down to a memory lane. It was a wonderful time I had spent in this institute. So without wasting much time, I'll take you to the subject. Of course, I don't know whether anyone of you have any legal background, or I'll make it little simpler in case if you have it, or otherwise also. Criminal laws, now almost for last more than 150 to 200 years, this country's criminal jurisprudence is carried forward with the help of three major acts, which are commonly known as major acts in criminal side. Those who are practicing on criminal side, we call it a major act or 3-in-1, very commonly called as 3-in-1. That is, three books are compiled in one book, so we call it as 3-in-1. It looks something like this. So what were those three acts? One was Indian Penal Code, now which is substituted with Bharatiya Nyaya Sanhita. Then second one was Criminal Procedure Code, which is now renamed, or a new act which is being introduced is Bharatiya Nagarik Suraksha Sanhita. It's little tongue twister. I am going to address all about this also. And thirdly was Indian Evidence Act, which is now known as Bharatiya Sakshya Adhiniyam. What are these acts all about? Now the name suggests, right? Indian Penal Code, act which notifies what action can be termed as an offence, and if that offence is committed, the person can be punished as is directed or as is suggested in the Indian Penal Code. Similarly, Criminal Procedure Code is about if a person is prosecuted. If a person wants to prosecute someone, then he has to follow certain procedure, right? And therefore Criminal Procedure Code, which was the old act, which rather is still an act, but from 1st July it will become a old act, a repealed act. And the third one was, if that procedure is to be followed, then what can be received as evidence, what can be rejected or cannot be termed as evidence and has to be rejected by the court, that is notified under Indian Evidence Act. In British era, somewhere in 18th century, when there were no laws in place, the laws for presidency towns like Bombay, Calcutta and Madras, the laws were completely different, and for those Mufassil areas or small towns like say Kolhapur, where I come from, the acts were completely different, because everyone, the king of that area or the person heading that area would decide what he will say, that this action is offence, this action is no offence. Likewise, then the Britishers felt that we must have some guideline, which guideline can decide as to what can be termed as an offence, what cannot be termed as an offence. So the great Lord Macaulay, he was asked to look into this whole issue and he started working on it. About 1834, he started writing or codifying, we can call it as codification of laws. So he decided that he started working on it somewhere in 1834. The first draft by Lord Macaulay was ready by within about 7 years or 4 years rather. By 1837 it was ready, the first draft, which had it went under many revisions. Finally, after about 26 years, then Chief Justice of one Mr. Peacock, he fine-tuned that final draft, and then ultimately it came out in 1860 as final draft as IPC, which is known as Indian Penal Code, which is still in existence even now. So you can imagine 1860 till now we are following the same law. Now you may ask me one question, that how come that same acts are being followed by our country? Lord, as I can use this phrase, that Lord Macaulay was a great engineer according to me, with the kind of precision you people study and then you come out with your ideologies and all. Same was done with his vision, because see, he had not committed any offence, but what can be termed as an offence, he compiled it so well that it has stood the test of about more than 150 or more than that many years. Still it is considered to be one of the finest legislation across the world, our Indian provision, because you can imagine the diversity what India has, right? We start from Kashmir, then it was to much larger area, but now let us look at it, that right from Kashmir to Kanyakumari, from east to west, that entire nation, it's a huge nation. With every about 100 kilometer your dialect changes, your language changes, and still that act is applicable throughout country. So you can imagine what kind of thought process must have been applied while drafting this act. So that was one aspect where it was codified as to what can be termed as an offence. That was decided as Indian Penal Code, that was of 1860. Similarly, work also started on procedure part of it. Now somebody has to be prosecuted, then how he can be prosecuted? So CRPC was thought about. So Criminal Procedure Code, we call it CRPC, but that is Criminal Procedure Code. So what procedure is to be followed if somebody is to be prosecuted, that was codified, or that was done under CRPC. Again, that also took about 40 years or something. So the first final draft of Code of Criminal Procedure came somewhere in 1898. Somewhere in 1898, the first procedure code was formulated. That underwent a lot of changes. Somewhere in 1973, the earlier act was completely repealed and the new act, Code of Criminal Procedure, was reintroduced in India. So since then, since 1973, the act has been in vogue. And the third part was that about what can be termed, as I said, that initially a king will decide what this gentleman is talking about is a correct contention, and I must accept that as a gospel truth, and therefore I can convict a man. This whole thought process was changed and they codified as to what can be received as evidence. So evidence is something like, when I joined the profession, I used to get amazed with, or I used to say like, what are they saying? So when I used to go in High Court, and the entire work happens on documents. So actual accused is not brought before the court unless he is sentenced to death. So in that situation, the judges used to say that, we cannot read this. I used to get amazed, why the judge, he knows English, the document is in English, what is the problem? Why they are not able to read it? So then I realized that a judge can read only such document which has been proved as evidence before the court. So the trial court receives certain things as evidence and that can be received once it is accepted as evidence. Only those documents can be then read in the higher courts. So what is that evidence? What can be received as evidence? What testimony can be accepted as evidence? Like a common thing, like law does not permit hearsay evidence. Now what is hearsay evidence? Is that when what I have myself seen it, what I myself I have heard about it, or what I have perceived about it, it's my direct evidence. But if some third person comes to me and says that I have heard one Mr. X committing robbery, and this fact which I heard from somebody, if I convey to the court, then that is not considered to be evidence, because it is called as hearsay. What I heard, I said it, and that should not be accepted as evidence. Now these all are the factors which can be considered as evidence, which was then agreed that this is what will be treated as Evidence Act. So in 1872 the final Indian Evidence Act came into force, and since all these three acts have been in place for more than 150 years, which are being effectively used, and even those not only that effectively used or something, but where the justice has been dispensed with the help of these three acts, the government felt that there is need for some change in this whole act, that basically because of the changing scenarios, situations and all. So government came forward with three new acts, that is Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. So all these very three acts are reintroduced. These earlier acts would be repealed. Repealed in the sense they will be applicable to all those offences which are committed till 30th June 2024. From 1st July, midnight of 1st July 2024, these three new acts will come into picture. Generally the procedure code is retrospectively made applicable, but here is a case where they are going to apply it prospectively. So if I commit an offence on 30th June 2024, I will be prosecuted, punished, or the evidence would be received as per the old acts. But if I commit post 12 o'clock the very act, I will be prosecuted, punished or dealt with by virtue of the new three acts. So as I said, there was a lot of opposition, forget anyone else, but from we lawyers, because we felt that why are you changing, we are so used to it. See, I have completed 25 years, I personally feel it took me 25 years to understand what this law is. Today I feel somewhere after spending 25 years at the bar that now I have started understanding this law all about, and suddenly they have declared that no, Mr. Mundargi, stop reading these laws, start reading new laws. I said, God save me, now I am back into the same situation 25 years back which I started reading, I am going to start afresh. So that kind of opposition a person like me I had. There was one more issue about Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. What are these tongue twisters all about? One more opposition from our side. It is going to be very difficult because it's very easy to say IPC, CRPC and IEA for us. Now what is this new ways of BNS, BNSS, BSA, what now, how am I going to just remember all these things? But because of these very reasons that I had to say something about this, I started reading and I realized that the government, the legislation has really thought over even these names. Firstly, these are all Sanskrit words. This is our Indian culture. Sanskrit is the language base for not only any Indian languages but even abroad. If you go to Germany, if you go to Russia, dver, dar, the door, in Russian language it is called as dver. Dver basically is very something which emerges from Sanskrit. So these names are not something we are unfamiliar because we don't follow our tradition, which is our original tradition. These are all Sanskrit names. And now I will explain you each name. So far as Bharatiya Sakshya Adhiniyam, it is a clear translation of in an Indian language. Indian Evidence Act is Bharatiya Sakshya Adhiniyam. So Adhiniyam is rules in Bharatiya Indian, Saksha, Sakshi is evidence. What kind of rules should be followed while receiving or rejecting any kind of evidence is guided under Bharatiya Sakshya Adhiniyam. Now, so far as Bharatiya Nyaya Sanhita, this is a replacement for Indian Penal Code. Earlier, the whole approach was to penalize someone. Penal means what? For punishing someone. Indian Penal Code would describe that under, if this is your act, you will be punished under this. No, the approach is, there is a slight change in that. The approach is something different. Today, they don't say that somebody should be only punished. It is about dispensing with justice. Bharatiya Nyaya Sanhita. Nyaya is to do justice, to dispense justice. So, punishing someone is justice with the person, that you are punished for doing this act, you are being punished. So, that is justice in, though he may get aggrieved by that, but that is actually a justice for him and simultaneously a justice to whom the offence has been committed. So, if a person commits, say he assaults somebody and commits his attempt to murder, the man has suffered something. So, he also gets justice because somebody who has committed the act has been punished for that. So, approach is slightly changed, that it is not only about punishing someone, but it is about delivering justice to parties. So, therefore, Bharatiya Nyaya Sanhita is about how to deliver justice to the parties. Now, Bharatiya Nagarik Suraksha Sanhita. What is this Bharatiya Nagarik Suraksha? Bharatiya, Indian, Nagarik is citizen, Suraksha, Suraksha is the safety, and Sanhita is code. So, compendium, what we can say. So, what is this? This deals with the procedure. As I said earlier, the act was Criminal Procedure Code, right? So, criminal procedure, it just gave the procedure that if somebody is to be prosecuted, if some application is to be moved in some court, or you have to approach some authority, what is the, how one can do that. Now, it is not only about that, but the whole approach of the legislation is now that if a person is to be prosecuted or this very action, then one has to look at few things, like when a person goes to court, like if somebody commits an offence, so if he is to be prosecuted under any of these provisions of Bharatiya Nyaya Sanhita, then he will be produced before court. He has his own rights, like it is, one has to balance it out between the rights of a victim, rights of an accused. Everyone has rights. See, a person is a citizen of India. If a person is prosecuted, he has his own rights just because he is committed, like a very famous, rather infamous case you all know. There was lot of flack, there was lot of opposition when a person by name Kasab was arrested. Entire country, entire world had seen him committing the act what he did. And so there was lot of opposition even from lawyers. Some of the lawyers were agitating why he is given a lawyer, why he should be defended, he should be hanged. No, our constitution does not permit that. In fact, that was a glaring example what we presented before the entire world, that even though everyone knew what Kasab had done, still he was given the best possible legal aid, where he could actually be represented properly. In fact, when Justice Tahiliani held the entire trial, during trial he ensured that a proper legal support is provided to this accused. At one point of time there was some grievances raised by the accused lawyer. He was removed by the judge and another good lawyer was appointed, and who conducted and completed the trial. So you can imagine, there was in that whole thing there was one more very unfortunate incident. One of my very close friend was representing another two persons who were jointly tried with Kasab. There some gangster sitting abroad felt that this is against Indian, he was firstly a gangster. Still he chose that no, this is something happening against my country, who that so-called gangster is sitting abroad, who is not, had no then capabilities to be here and face the prosecution against himself, but claimed that no, this lawyer should not be allowed to defend those two persons because they have done some act against the country. That unfortunate, that lawyer was murdered in this whole process, who was my very close friend then. And if you people know about, there is one film made on that lawyer by name Shahid. But anyway, I am slightly deviating from the subject. But basic idea is that Nagrik Suraksha. So every citizen has been given under Article 21, the basic constitution of our country. It provides for certain rights to everyone, whether he is a common man, he is an accused, but if a person is to be produced before the court or if he has to be defended, there are certain provisions. So the idea under Bharatiya Nagrik Suraksha Sanhita is that if a person is facing or a person wants to initiate any action, then he should be given complete support. His safety does not mean that only his personal safety, but his rights are safeguarded under this code. Therefore, the name is Bharatiya Nagrik Suraksha Sanhita. So the whole idea of legislation today is that don't look at in conservative way that I have to punish someone, so Indian Penal Code, but look at it as I have to deliver justice to person. I have to deliver justice by imposing a punishment on a person who has committed the act. At the same time, I have to ensure that the justice is given to a person who has lost in that whole process. Similarly, if a person is to be prosecuted, then still, even though he is an accused, his rights are taken care of, their rights are kept intact, they are therefore Nagrik Suraksha, they are safeguarded, rights are safeguarded under the procedure. And likewise, these names have been given. So these tongue twisters, we will have to get used to it because these are our languages. So even though it is Sanskrit, it's advisable to adopt more than anyone else of you. I must firstly get used to this kind of language. Well, it has been 24 years I have been using those code languages IPC and CRPC. Now, with the, of course, advantage of technology, as I said, then it took about 26 years, 40 years for compiling all those acts. There was no support of technology. Today, we are in this era where technology is rather, it's riding so fast that we are getting guided by technology instead of we guiding technology and we creating something. So with the help of technology, obviously the legislation has taken about 3 to 4 years approximately for compiling these laws. About 4 months time was taken for actual promulgation, and by 1st July we are going to start facing this whole 3 acts. There is, I am going to share some comparisons between old act, what is this new things that they have incorporated. I must fairly tell you one more thing. As I said that they are legal engineers, the Lord Macaulay and Peacock, Justice Peacock and all, who had then created this kind of, I personally feel these are one of the best books, because what I always feel, law is nothing different than logic. When I stand in the court, I always look at it logically and I try to present a case logically, and if it appeals to the judge, he will accept it. The whole idea about law is that apply the logic to a situation and present it before the court. I don't have to say that every time if I start getting up and in the court and saying, addressing the court, that my client has done nothing, he is innocent and sit down, the judge is not going to accept. Many a times I will have to explain the situation, in what circumstances this incident has happened. Obviously, there are materials to suggest that the incident has taken place, but what are those circumstances? I need to explain that to the judge by giving a logical face to it. Now, therefore, all these 3 laws, if we look at, there are about 1069 provisions under these 3 new laws. They have taken, the legislation has taken about 3 to 4 years to compile them by virtue of those 3 new acts. You can imagine then in 18th century they took, as I said, 26 years or 40 years or whatever number of years. They had no support of any technology. Today everything like ChatGPT, I come to know about it, and we are like, we see here that ChatGPT, the one subject is put and there are thousands of lines which come in front of us. We get scared of reading those 1000 lines, but see, this is at a tip of tongue, you get it, you just press a button and you get everything ready-made. So that has helped to compile it faster, but at the same time I must tell about, barring some amongst these 1069 provisions, barring 30 to 35 provisions, rest all provisions are same. Therefore, I say that these were the legal engineers. What they thought with the common sense, that something they have written and which survives even today, only that this time legislation has done something, some difference, that I'll tell you few provisions how it can be said. Like, firstly, let us, the minimum changes are in Sakshya Adhiniyam from Indian Penal Code, because what they have thought is about, if you decide that this can be treated as evidence, it is very commonly said, like a person who is arrested, who is under arrest, is investigated by the police agency. Now, many times you must have read in the newspaper that what police do, it's a very common practice, though it is not right, but it has happened in many cases, and which serious note is taken, cognizance is taken by the courts also, that in custody there are atrocities effected on these people. So, under that threat or under such kind of situations, what happens is that the person says that yes, he accepts his guilt. Whether that can be treated as evidence? The answer is no, because somewhere down the line there are few first principles which have been laid down in 18th century, is that the person who is prosecuting the accused would be interested in ensuring that what he says is right, that is established as a correct fact in the court, and therefore he will ensure that the person is proved to be guilty, because he is accusing that. Ultimately, if some offence happens in contest with a common man, he goes to police and lodges his complaint, right? So the police takes over that complaint and starts investigating. During investigation, they will catch hold of a person and say that you explain as to why have you committed the offence, and in that whole process, if third degree is used, he is obviously, to save himself, he is going to, or he is bound to say that all right, don't hit me, but I have committed the offence. So, can this be termed as a evidence? The answer is very simple, no. So, that these things have been said in 18th century, even they are said today also. The new act does not deviate from that. So, these are the common things which are continued. But what is that thing that has been improved in today's Bharatiya Sakshya Adhiniyam? Something which is close to all of you, the electronic evidence, with the technology and all, offences are no more offences like they used to be in earlier days. Like about 30 years back, the offences were only about offences against the person, forgery, signatures are forged or something of that sort, wills are forged, somebody is murdered, some woman is sexually assaulted. These were the nature of, principally, these were the offences. But with the change in the scenario, with the development in the country, the nature of offences have changed to large extent. Now it's mainly white collar crimes. A person who is sitting in his with his credit card in his pocket does not know that this very credit card is used somewhere in the different part of the world. Now these offences require some more options for the legislature. So the whole concentration is that besides retaining all the earlier provisions, they have come forward with cases like how it can be improved about these offences with the help of electronic media, social media, if the offences are committed, how they can be investigated, how that can be received, then collected and presented as evidence. Now, while reading this whole new act, some things even came to my mind. You all must have, I recently came across one episode where one of my friends showed me a clip on this social media. A very famous song from that Fana, Chand Sifarish, everyone must have heard it, Chand Sifarish, that song was on Amir Khan and all. Now that song I heard in the voice, it was a duet, it was sung by late Kishore Kumar and Mohammed Rafi. Most of you people must have also come across, because social media is everywhere. What I see, you all must have seen it. I was surprised, the same voice texture, the way of pronouncing the words, their whole the genre even the way there are many common songs sung by these two great singers, Mohammad Rafi and Kishore Kumar, but both of them had their own style. So I could see everything in that, the voice, the texture of the voice, the throw of words, their whole style, everything perfect. I said, how they could do that? Now this is all artificial intelligence. So even in spite of this Bharatiya Saksha Adhiniyam coming into play, we still are going to face this situation, because I will give a very common example. Earlier days, when these trap cases, like a person is arrested red-handed while accepting the bribe. Now there was a very common way to look at it, that if somebody makes a complaint, a common man goes to the anti-corruption bureau and says that there is a demand which is being made, my regular work is not happening, the government servant is demanding a bribe from me. What they used to do, that they used to put that some small some device here, the cassette will be playing, and he will go there, he will start asking that, sir mera kaam ka kya ho raha hai, then he will say, arey aapne paisa laya kya वगैरह. So what is that? So they improved, they started putting some pens with some camera here, so that the gesture they could not capture. So what they used to do is that they improved that only voice recording is insufficient, because sometimes they used to be smart, they used to aise karenge. So that will not be covered under the this in the audio recording. So they started, okay, now we'll overcome this situation. They started putting that hidden cameras. So that could cover even this aspect. Now, so when these matters used to come with those audio recordings, they used to be presented, and this was a very common defenses. Even I have raised it in a couple of matters, where we used to say the defense that, sir, when that person will come, the person who has identified and found similarities in the these two voices, sample voice of the accused and this recorded voice of the accused. So we used to say that there are very common ways, that there are people who can actually mimic somebody else's voice. This is a common way, and this was a very common defense raised. But still, there was a possibility to overcome these kind of defenses, because however it is like a signature. Same person, I myself make two signatures simultaneously, still there would be a slight variance. I cannot, if it is exactly identical, there is every possibility that it is a forged signature rather. So that variance has to be there in every signature, because there are many, how do I hold the pen, in what mental situation I am signing. These are all multiple reasons why signatures can differ from my own signature. Likewise, the voice also could be said by a mimic artist, can also come with the same voice, with the way I am speaking with you. But now with artificial intelligence, something more has come to that is thrown towards the legal situation, the jurisprudence now. Now we don't know how to deal with it. Rather, we all would be looking at you people, that please come forward with some more material that we can overcome this situation. Where there is possibilities are two ways. Either a person can take a defense that this is not me, this is all deep fake, or something that nowadays it is said deep fake, and it is not me, it is the person who is seeing here in this poster, it is not me, somebody else is talking to you. The voice is not mine, it is artificial intelligence. This can be a defense also, and this can also be a situation where actually somebody else can be prosecuted. More pictures where something one could understand that. So in earlier Indian Evidence Act, there was a way that there was a 65B certificate, which was an amended provision which was brought in. What was that? So an expert would say, he would look at a device, he will say the device is absolutely in a working condition. From this device I saw that there was a Morse document, I took a printout of that, every printer was in order. Likewise, he will certify what he has seen there, and that certificate was accepted as something to substantiate the document. Now with a new Bharatiya Saksha Adhiniyam, now there is a separate provision to it, and not by virtue of some amendment it has come. So likewise, there is a separate chapter where this all electronic things, how it can be received, how it can be preserved, how it can be presented in the court as evidence. These are all given under the new Bharatiya Saksha Adhiniyam 2023. Now, Bharatiya Nyaya Sanhita. As I said that there are little more changes into that. Of course, I am not troubling any one of you with that each and every what are these change in that each provision. I don't want to trouble you, because I myself I have not troubled as such till now, but which I will be doing in the month of May. But anyways, basic principle what they have looked at is that firstly they have given precedence to, as you have seen that Nirbhaya case happened few years back. The legislation immediately came forward with a case of POXO was introduced, that a new act came to be introduced, because this child abuse was happening in our country for years together. Not only the outsiders but even family members were indulging into child abuses. The legislation felt, after this Nirbhaya episode happened in Delhi, legislation felt that we must do something about it. There has been a lot of curb to it, but still it has not stopped. So the legislation felt that we are the way Indian Penal Code is proceeding, like they are given precedence to the small like offences which are much what we call not that serious in nature, and 302 a chapter like the offence like murder was at 302. Then offence against woman for rape was 376. Now legislation felt, no, let us give precedence to that kind of offences. So those offences are brought much on higher pedestal in the sequence of sections. Similarly, they have changed or deviated or they have made some changes about the punishment also. Now earlier the life imprisonment, generally in general parlance it is life imprisonment means 14 years. This is what we commonly think about it. Actually it is not so. Life imprisonment means life, you have to spend rest of your life in prison. But there are certain rules where by virtue of which a person has committed an offence of murder. I'll just give you an example. He commits an offence of murder proved against him and he is sentenced to life imprisonment. So logically speaking, he has to spend rest of his life in jail. But it does not happen. After 14 years, generally people come back. And it is not only 14 we commonly know it. But there are categories, like if it's offence against some political party, this person or something, assassination and all, then it is minimum 28 years. Likewise, there are categories. So these categories are decided when the person can be actually released. Then there are his good conduct helps him. Then there are yearly few holidays are there. Similarly, a person can come out on parole and furlough. Like furlough means what? A person otherwise remains in jail, but every 2 years he gets, after he is convicted, if he has completed certain years, he gets 15 days leave from the jail, so he can go meet with his family and he has to surrender back to the jail within about 15 days. That is furlough. Parole is something different, where a person, death parole, some unfortunate incidents, a person loses his family member, so he can come out on parole. There is a wedding in the family, so he can come out, join the wedding and he has to go back. Now these periods are also considered as his period in the jail. Now these punishments in certain cases have changed. Like if a person commits a rape and brutally murders, then it is life till remainder of his life. So now the provisions are very clear. If a life convict, a person is released, it's not necessary that person should remain in jail, right? That a person is convicted, in his appeal the court finds that no, there is some substance in his contention, his appeal is likely to take some time to be heard. So allow him to go on bail by suspending his sentence. So he is out on bail while his conviction is still in existence. And while on bail, if he commits the second murder, then on second conviction he goes inside for life till remainder of his life. So likewise the certain provisions have changed. Similarly, certain provisions like defamation and all, they have been made it much easier now to face. Then certain terrorist activity, terrorist activity, organized crime are brought within the four corners of this. There are separate offences like MCOCS, a state legislation. We were the first state to start or adopt this act, which was MACOCA. We commonly call this MACOCA or MCOCA, Maharashtra Organized Crime Control Act. Now that was meant for those gangsters who were getting into this kind of activities where common man, the builders and all were being extortion used to happen, their children were kidnapped, murders used to happen. So therefore that organized crime was brought in, but that's a state legislation. Now this central act, that is Bharatiya Nyaya Sanhita, brings within its four corners these provisions like organized crime or terrorist activity. These are also covered under this centralized act. So these are some very interesting features of this new act. The major changes have happened in Bharatiya Nagrik Suraksha Sanhita. The three tenets basically about this act are the personal liberty, speedy justice and procedural fairness. As these three things can denote personal liberty. Personal liberty is what? Basically personal liberty would be in context with the accused, principally in context with the accused, because if somebody is prosecuted, his liberties are curtailed. So that liberty can be curtailed by following certain procedure. A person cannot be without giving him opportunity, cannot be kept behind bars. We are not into that kind of regime where we are giving a complete opportunity to an accused who is facing a prosecution, right? So personal liberty in context with an accused. Then speedy justice, again it is to strike a balance between both the parties, like a victim as well as the accused. So both will have benefits of speedy justice. I'll give little details about this. And the third one is procedural fairness. Again it deals with fairness to both the parties. Now as we say that it is not only between accused and the victim. When accused and victim versions are to be tested, they are not tested by both of them, but they go to a court of law, right? So therefore in that whole process, how many parties are involved? One is the accused, firstly the victim, he goes to police. So then comes police into picture, the investigating agency. Then police catch hold of an accused, third party comes into picture, that is accused. And then all three of them go to a court, so the judge comes into picture. So all these four people will, four parties will have to be, the balance will have to be struck between all four of these parties, right? So firstly let us look at this personal liberty. Now earlier days when the first draft came in, the very first draft in 18th century which came in, the whole idea about investigation was about if a person is arrested, the police were given only first 24 hours of his arrest to investigate. If they are able to investigate in the crime, then take him to the court. But if they are not, and then they will have to take him to the court and ask for further custody. So legislation realized that in 24 hours it is impossible to investigate into in context with an accused. So what they did, they came forward with this provision that within 24 hours you try to investigate, but if you are not able to complete your investigation within 24 hours, take him to the nearest magistrate and request to the magistrate to grant the police custody. Once that police, and how many days that police custody can be granted was given that 15 days. So at the most, from the date of his being produced before the magistrate, first 15 days was granted to the police to investigate into. Now whether entire 15 days should be given or only few days are sufficient, that discretion is always with the magistrate. So what they could do is that 15 days time is given. So therefore the first provision was within 24 hours try to complete your investigation by, if you have arrested an accused. If not, then go to take the accused to the magistrate and request for your police custody. So the magistrate will look into it and he will at the most give 15 days of police custody. Thereafter the accused will be taken into judicial custody. as I said, that some accused came with a novel ideas, that accused would suddenly start having a chest pain. Now, which police officer will take this risk? He would take the accused to firstly, because whenever accused is to be presented before the magistrate, he has to be taken to for his medical. The doctor will check that everything is in order. He will certify to it that his medical is done and he is absolutely in good condition. Thereafter, the person is generally produced before the magistrate. So they will start saying that I have a chest pain. Some senior say about 60-70-year-old man is arrested. He would tell it's very easy for him. He has to just hold his hand here and just start showing some giddiness, and the man will be taken to hospital. And if some slight palpitation, and obviously anybody would have it, if a man is actually arrested, he will obviously have some palpitations or some high blood pressure, something or the other will be there, and the doctor will say no, let him be admitted, let him be under observation. And if he succeeds in remaining in hospital for those 15 days, then police, in spite of arresting a person, can do nothing about it, right? So, legislation has dealt with it, the new legislation has dealt with it. Now, how do they deal with it? That in such scenario, they have said that yes, maximum police custody 15 days, but it is not necessary that it should be from the first day of his production. You will get about 40 days to or 60 days, as the case may be. There are two different kinds, where punishment is up to 10 years, then it is first 40 days. If it is beyond 10 years, so it is life or something, then up to first 60 days from his arrest, any 15 days. So if a man is actually claims to be having some patient of something, he can be taken very easily to a doctor. Once he gets absolutely fit, he can be taken back to the court and said, and now we want his custody. So that is one thing. There is another advantage to it, that there are some offences where there are multiple accused, right? So some person absconds, one person is arrested. So today I arrest a person. Now an investigating officer wants to confront him with another accused who is absconding at this point of time. Now how does he deal with it? So what he will do is that once he is arrested, within that 40 or 60 days, he can again seek his custody of the first offender who was arrested, and he can confront both the accused in front of each other. So these kind of things which would surely help for a good investigation. Similarly, a situation that there are offences registered against unknown persons. The victim does not know who is. Suppose a robbery takes place or a dacoity takes place in his house. He has not seen because the unknown persons have come, dacoits. I would not know who the dacoits are. So he gives a description. Police start investigating a offence. Dacoit is some dacoit with some help of some informer is arrested. So how do they start getting his police custody first? So firstly they will have to identify that he is the person who has committed dacoity or the robbery, right? So what do they do? That this situation is advantageous for the investigation, where he can be produced before the magistrate and say that we are sending him to judicial custody. Once his identification parade is held, only then we will seek his custody. So that would be a fairness in the investigation. Now how do they do that? This is the first principle, since it is in existence since ages, that if in identification parade is to be held, what we see in the films, it is all absolutely humbug. It is not so. While in police custody, one cannot have this test identification parade. The test identification parade has to be held at an independent place. So where do they hold it? Generally in a place like Arthur Road Jail or a school premises, somewhere where there is no possibility of police influencing a witness, because again I said, if a police can use third degree against a person to make him confess something, they can also tell the victim that you go and we are going to show you one man, you have to go inside and identify him, right? So to ensure that there is no such interference of investigating officer, the identification parades are held while they are accused are not in police custody, and it is held at independent place. So now this a genuine investigation can be really helped with this scenario today, that the man will be in judicial custody once he is identified by the victim that yes, he was the person who had entered my house for committing dacoity or the robbery as the case may be, the man can be then actually brought before the magistrate saying that look, there is a report of this test identification parade, the man is actually identified by the victim and now we want to investigate as to who are the other people who are involved in this offence, what has he done with the loot that he has received during dacoity, what has he done with that loot, all these things can be investigated into. So this is how it can be, it can help. So these are some very interesting features of this Bharatiya Nagrik Suraksha. Something similar is about judicial custody. Now what had happened, actually this is there is going to be lot of litigation according to me, because somebody would obviously challenge it or something, but now the legislation has made it very clear, if a person is in jail, in a prison, then only it will be treated as judicial custody. Means what? Like I'll give you an example. As I said, the first example which I gave you about a person being in hospital, that he remains in hospital, police don't get advantage of for the purpose of investigation. Similarly, there are multiple examples, you must have also seen it in many politicians or something, they are in jail but they are actually not in jail, they are somewhere in hospital, in some good 5-star hospital. Now, no more this hospital business, because if somebody is in hospital, that will not be treated as a period undergone if a man is actually convicted. So those days whatever I have spent in hospital will have to be spent separately again subsequently in judicial custody. So those days, or house arrest, in some of the decisions or even High Court, Supreme Court has permitted house arrest. A man is actually under arrest but he remains inside his house and he is not allowed to get out of his house, he is not allowed to use his mobiles and anything. He, as if he is in jail but he stays in his house, but that is called as house arrest. Now no more this house arrest thing will be treated as judicial custody. So this is another feature of this Bharatiya Nagrik Suraksha Sanhita. This is going to cause a little chaotic situation for a simple reason, because if I am saying that I need hospitalization in a genuine case, then whether a officer would say, okay, now you are allowed to go on bail, because I cannot treat you to be in judicial custody. So do I send you on bail, or should I? This would amount to a violation of Article 21, would be another question, but of course that is not the subject to be discussed today, where this probably would be discussed further sometime. So then second part, as I said, was about speedy trials. Earlier, as we have seen, there are many cases where the cases linger on for years together. Now sometimes it is detrimental for either sides, like in a case of accused, if he is out on bail, then the case remains pending, because the priority is given to those matters where the accused is in jail, correct? So therefore priority is given to those kind of matters. The accused remains in jail, outside the jail, so he is roaming freely, but the person in this whole scenario who suffers most is the victim. Say, imagine a situation where a person is murdered, his wife is the first informant who has lost at a young age, say about 25-30, she loses her husband in that whole process and she is struggling with his life, but she wants that the person who has committed my husband's murder must be prosecuted, punished, penalized. The man is unfortunately on bail. In that scenario, the matter is not given precedence, and when the time comes to actually framing of the charge and starting with the trial, at that time he makes a request for discharge. Now I will just explain what is framing of charge. Framing of charge means the judge will frame the charge, so he will be explained as to for what you are facing this prosecution. So that is explained to the accused, that is meant by charge in common language. So that is the starting point of any trial. So after once the charge is framed, the witness will be called, they will be examined, cross-examined, and all these things happen, and then the decision comes whether the man should be acquitted or convicted. So that is the trial process. So earlier what a person knows, that if the trial concludes, I am surely I am likely to get convicted. So what is the best way out today? Today let me apply for discharge and let me try and delay this trial as much as possible. Now new provisions which are brought in by virtue of Bharatiya Nagrik Suraksha Sanhita is that there is a timeline given on many aspects, like within how much time one can even apply for discharge. There is a time frame. So within that time frame only the discharge can be. After that, if I just to delay something, if I make application, that cannot be entertained. Similarly, there are some as I said that this Bharatiya Nagrik Suraksha Sanhita does not talk only about the accused, but it talks about every party which is concerning the case is taken care of. So how does that, like in many cases there is some property involved. So there is accusation about some property, then the property could be seized. It could be a bank account, it could be a property, landed property, seizure, and all this used to take place. So the police on their own would go, seize it, seal it and come back. Now if property is to be seized, then they are required to give notice to the concerned party. So explanation can be sought. So there is also a time limit. Suppose the seizure actually takes place, police have to inform the magistrate about it within a specified time limit. If an accused is to be medically examined, he has to be medically examined. That report is to be submitted to the magistrate within specified time. If a victim of a rape, for example, if that victim is to, because these medicals are very important aspect of it, even that has to be done. It has to be done within time frame, and that has to be submitted to the court. So likewise the timelines have been prescribed now. Now they have to be strictly followed. That will curtail the whole entire period of trial, where from starting point till end of it. One aspect which is now little imposing on the judicial officer is that there is a provision that once the matter is closed for judgment, he has to deliver a judgment within 30 to 45 days. Now one can say that 30 to 45 days are good enough for a person who has heard the matter and he has to deliver a judgment. Certainly it's a good period, not that it is very less, 30 to 45, basic 30 days, and it can be extended up to 45 days, so 15 days grace. No doubt it is good period, but imagine a situation that there is a bulky record and due to irregular transfer the judge is transferred. The new judge comes and looks at some 10,000 pages of collected evidence. He will have to analyze it. That 30 to 45 days would be really less time for him, because he has to analyze it, because ultimately he has to dispense with the justice. Not that he can just to complete something within 30 to 45 days, that he has to write something and say that my job is over. He'll have to apply his mind, because it is about somebody's life and liberty, about a person if he is to be convicted. If he is wrongly convicted, then that would be injustice. Similarly, if a man is acquitted for in spite of his offence being committed, it would amount to injustice to the victim, right? So therefore he has to deliver a justice which he will have to strike balance. So I personally feel that there should be some scope to give some leverage to the judicial officer also, because that gentleman sitting there will have to actually apply his mind, and it's not a very easy task, because sometimes it takes us also to understand the matter. The man has to sit on papers which he has not seen, and then deliver a judgment on that, and which will be tested immediately by the higher court. So somewhere that pressure also would be there on the judicial officer. Then there are some good things like audio video technologies. With this new technology, audio video has been introduced. Like if some searches are to be done, if a person is giving some confession, everything has to be, or a statement of a victim, rape victim or something is to be recorded, it has to be recorded under videography, audiography. So these are some good provisions, because then there is less likelihood of tampering with the things, and these all have to be submitted in the court. Similarly, there is something like trials. Trials also can be done on audio videography. If a witness is staying abroad, trials are delayed for that, because the main witness is say in USA. He says that I cannot come there. the accused is getting benefit, or sometimes even accused is facing a flag, because if he is not granted bail for want of that witness, I have seen many cases where people have spent about 8, 9, 10 years behind bars and the trial is yet not over. So this is not justice. So to overcome these kind of situations, what they have done now, they have allowed all virtual hearings. On virtual hearings, under the law itself, the judge can record the evidence of a witness who is sitting abroad or who is unable to come before the court. Now this is very good provision. These are some things about procedural aspect. Now there is one very interesting procedure which is brought into service. Like I have a grievance against, say, one X person who is my neighbor. He owes me money, which is otherwise in common parlance. Suppose if I sell this device to somebody for 100 rupees, he takes the 100 device for 100 rupees and pays me only 50 and says that balance 50 I will pay you within 1 month's time, and the man vanishes, he does not pay me 50 rupees. Generally what we call, अरे he cheated me, उसने मुझे उल्लू बनाया, मेरा 50 रुपए खा गया. So we generally in common parlance say that he has cheated me, but in the eyes of law, whether this is cheating, no is the answer, because the intention to cheat has to be from inception. So if I sell this product to somebody, say for 100 rupees, and he says that okay, I will give you 100 rupees, right now give me this device, he takes it away and pays me nothing. So his intention was to cheat me from inception. So that is a distinction. So sometimes it happens that a loan is taken of say a crore of rupees, about 45-50 lakhs are repaid, and then unfortunately the man faces some financial problem and the balance he is unable to pay. Now whether that can be treated as criminal case, no is the answer. But what these people do is that they will suppress few things. They will say that there is amount of 45 lakhs which he owes me, he has not paid me and he has committed cheating with me. The person goes to the police station, magistrate's court, and says that you issue process, ask him to face a criminal charge. Earlier at this stage, the proposed accused was never summoned. So the proposed accused has to come into picture only if he is cited as accused. The court takes cognizance of an offence against him and says that okay, now you come face the prosecution, where he says that oh look, I have receipts to show that I have repaid him 55 lakhs and only 45 is balance. Now that 55 lakhs repayment is completely suppressed from the magistrate. So now that provision is there in these kind of offences, the magistrate can give notice to the proposed accused. Now this is very interesting and I feel a very positive provision into it, because that can actually curtail a lot of litigation. So if both the versions are before the magistrate can actually apply his mind and say that no, this is, gentlemen, go to a civil court and sort out your issues, because this is no case of cheating. You have suppressed the fact of payment of 55 lakhs to you. So these are some provisions. Then there is one provision where in earlier CRPC there was a provision that a person where a private complaint is filed and court takes cognizance, like a cheating case which I just now told you, this can be treated as private complaint. But there are some serious accusations made where the magistrate finds that it is necessary that investigation should be directed to police to look into this grievance. That was called as provision under section 156 subsection 3 of Code of Criminal Procedure. Now earlier there were certain judgments that in this whole process, like very common situations which are faced in an area like Mumbai are that redevelopment issues. There are societies, they go under renovation, redevelopment. Most of the people agree at one point of time that all right, let us appoint one builder and we'll give him this redevelopment to him. Then that Mhada colonies are there and all these things. So that annexure 2 list is made. It is who person who is eligible, who is not eligible. Lists are made and everything is submitted. Finally, the decision of redevelopment is taken. Obviously, when a society or that cluster of houses is about having some say 500 people, at least 10 would be people who would be disgruntled people who would not agree with this. for genuine reason or sometimes for some other reasons which they are personally interested, for their vested interest, either the case may be. Let me not get into what is the reason. So these people can go to the court and say they will make accusation that the society committee members, they conspired with the builder, they conspired further with that MHADA officials, got this bogus annexure to prepared. I am, in spite being eligible, I am shown non-eligible. These are the bogus documents, or the person who has died few years back is shown as eligible here, whatever is their grievance, and they will go to the court and say that okay, direct, because this has larger ramification, go and initiate and request for investigation through police. Now in that situation, that MHADA official who has got nothing to do, he has never seen where that cluster or that society is all about, he also gets entangled and he is required to face a prosecution. Now in that situation, the provision under this new act is that if a government servant is prosecuted, give him notice. Don't direct police to register FIR and ask him to face the first information report, because when it is FIR, they are generally cognizable and non-bailable offences. So government officer who is discharging his duty, he must be afforded some opportunity. So this is one positive again provision, where the government officer can be given advance notice about that there is a complaint filed against you and there is likelihood that the direction can be given to the police to investigate into. One more very interesting development is that a trial can be held in absentia. Earlier, trials had to be separated. Say suppose two accused are facing trial. One is every day coming to the court facing, and then the trial does not go on with against him because the co-accused is absconding. Now the trials can be held in absenteeism of the absconding accused. So man, if he is absconding and not facing trial, cannot adversely affect the co-accused, one, and the justice can be delivered in that case. And that man can be, and there is only one provision given, that a person who is absconding, let him remain absconding. Whenever he is found somewhere, he will be punished as prescribed, but he should be given a legal aid. So a lawyer will be appointed for the absconding accused and he can be prosecuted. So in his absence, this is one more provision under the new act. So these are the major changes, as I said, in all these three acts. So in Bharatiya Sakshi Adhiniyam, it is about concentration, is about the new developments in this, like the social media and all these devices and all these are taken care of. So far as Bharatiya Nyaya Sanhita is concerned, it is about dispensing justice to a parties. So therefore the provisions of penal provisions have been changed. Priorities are given to serious offences than the little lesser serious offences. And so far as procedural aspects are concerned, there are some positive changes which have been introduced so that a more effect can be given in while dispensing the justice. So this is the whole idea about these new acts, and from 1st July onwards we will come to know much more about these acts, because these acts are to come into force from within less than exactly for 2 months from today. So that this is the all things what I could share with you all people. Thank you.
Thank you, Advocate Mundargi. I would request Professor Amit Agarwal to give him a token of appreciation on behalf of IIT Bombay.
Thank you so much. Thank you.